deadly weapon. Count 4, carjacking with a firearm, and count 5, possession of a firearm by a convicted felon. The first count, first-degree murder of a law enforcement officer, is the capital count, and that means that is the only count that if Mr. Loyd is convicted, he faces the possibility of a death penalty. Again, possibility of a death penalty. Florida does not have mandatory death sentences on any charge. So these cases are tried in 2 phases. The first phase is what we call the guilt phase. The guilt phase looks like every other criminal trial you may have seen on TV, or you may have sat there as a juror. It's the same thing. We conduct it the same way we do all criminal cases. And in the guilt phase, the jury's job is as follows. You all would be sitting in that jury box. You're going to listen to the evidence that is presented in this courtroom. Evidence comes in a variety of forms. The witnesses testify from this box right next to me. So you'll listen to witnesses. They'll be sworn in. The attorneys have the right to examine and cross-examine them, which is a fancy way of saying they both get to ask questions of the witnesses. There may be physical evidence introduced, videos, documents, photos. That's part of the evidence. Testimony is evidence, folks. The jury has to be able to see, hear, and understand the evidence that's being introduced in the courtroom. At the end of that presentation of all the evidence, you will then receive jury instructions from me. The jury instructions are the law that you are required to follow in the case. The jury decides what the facts are. I tell you what the law is. You apply the facts to the law. Your job then is to deliberate and return a verdict of guilty or not guilty on all counts. Your verdicts must be unanimous on all of the counts, meaning that each juror must agree on each count, either to acquit or convict. The burden of proof for the state is the same in the guilt phase of a capital case as it is in every other type of criminal case. It is proof beyond a reasonable doubt, and the instruction you will receive on reasonable doubt will be identical to the one that's given in all other criminal cases. The burden on the state is not higher because of the potential penalty. When you're deciding guilt in phase 1 of the case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not of the charges, including first-degree murder, on their own merits, and you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as any of the other offenses charged, or guilty of a lesser included offense, or not guilty. And we expect you to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. That's phase 1 of the trial. If and only if the jury returns a verdict of murder in the first degree, you then reconvene for the purposes of rendering a verdict as to which sentence, death or life imprisonment without the possibility of parole, should be returned. That second phase is known as the penalty phase. It only occurs if there is a guilty verdict on first-degree murder. First-degree murder is the intentional killing of another human being without any legal reason to do so, such as self-defense or insanity. There's no defense to it. It's you intentionally killed someone. If there is a guilty verdict on that, then there is a penalty phase. That penalty phase has a special set of rules and instructions, which I would give you at the time if we get to a penalty phase. All I'm going to do right now is give you an overview of what a penalty phase is like. Because the death penalty in Florida is reserved for only one class of crimes, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. The circumstances are known as aggravators and mitigators. The prosecution relies on aggravating factors. They are required to prove these factors beyond and to the exclusion of a reasonable doubt. These factors are limited by statute to 16 factors. The ones the defense relies on are called mitigating circumstances or mitigators. They don't have to be proven beyond a reasonable doubt. A mitigating circumstance or factor need only be proved by the greater weight of the evidence. It's a lesser standard. Mitigating circumstances are not limited by statute, and they may include matters that are relevant to the defendant's background, character, or circumstances surrounding the offense. And they will be offered as a basis for a verdict of a sentence of life in prison without the possibility of parole. Life in prison without the possibility of parole means exactly that in the state of Florida. We do not have parole. The defendant will die in prison. Before you may vote, the court impose a sentence of death. The state must prove one or more aggravating factors beyond a reasonable doubt. So there's like a second trial. The state puts on their evidence of aggravators. The defense puts on their evidence of mitigators. I give you the jury instructions, the law that you're supposed to follow. You then retire to the same jury room you all have been in this morning. You go back in there with your fellow jurors, and now comes the process of what we call weighing aggravating factors and mitigating. You got to weigh the aggravators and the mitigators. It's not a mathematical or mechanical formula. You don't go back there and add up the number of aggravators, add up the number of mitigators, and say, well, this side wins. That's not how it's done, all right? The first thing you have to do is determine whether one or more aggravators have been proven beyond a reasonable doubt. If no aggravator has been proven beyond a reasonable doubt, death is not a permissible sentence. The sentence is life without the possibility of parole. You're done. However, if a jury finds one or more aggravators have been proved beyond a reasonable doubt, you then have to go through the process of weighing the aggravators and the mitigators. And what that means is each of you individually, you can discuss this as a group, but you individually have to decide the importance or weight you give to each aggravator and to each mitigator. And it can be different for each of you. You may agree on some, you may not. And by importance, I mean, is this something that you consider to be important to the decision you're being asked to make, which is to vote for either life or death? All right. You can give things a lot of weight, a little bit of weight. You can find some things you just don't believe. You're thinking, I don't believe that. I didn't believe the evidence. It's up to you individually. But you have to be able to weigh those and come to a decision. Regardless of the weighing and of any decision that you come to, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the proceedings is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. In other words, the vote to impose death must be unanimous. Every juror must agree to that vote. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. Again, this is a broad outline of how this works. You would be given detailed instructions by me before you had to go through a penalty phase. Let me say something else too. The fact that I'm talking about the death penalty is not to be taken by you as any indication one way or another as to whether or not this is a case which justifies a death penalty. I don't know that, and you don't know that. We are discussing it at this point because it's a possibility in this case, and we must be able to determine whether or not you would be able to fulfill your job as a juror if we ended up in a penalty phase in this case. We're going to be asking you some questions about the death penalty. I'm going to tell you what some of them are, so give you a little bit of time to think about it. A lot of you probably never thought about this, never faced these kinds of questions. We are going to ask you if you have a position on the death penalty, whether you have any moral, religious, or personal objections to it, whether you're a person who believes that just because someone is convicted of first-degree murder, they should be sentenced to death. In other words, you think that's the only appropriate sentence for that type of a charge. We're going to ask you if you can go through that weighing process that I talked about. And by that I mean, when you reach a penalty phase, you have to be able to listen with an open mind to the evidence that's being offered by both sides. You can't be sitting in that chair thinking, okay, you go ahead and put on your evidence and then I'm going to vote the way I was going to vote anyway. You have to be able to listen, absorb the information, and give it due consideration. You may in the end reject it, but while it's being presented to you, you have to have an open mind about it. Many people have very strong feelings about the death penalty one way or another. Those feelings don't disqualify you as a juror so long as you can set them aside and follow the law as I instruct you. Your oath as a juror directs you to obey the laws of the state of Florida in delivering a verdict, and if you cannot do that because of your personal feelings, we need to know that today. All right. Let me change gears a little bit and talk to you about a defense known as the defense of insanity. Mr. Loyd has raised the defense of insane at the time of the offense in this case. This would occur in the guilt phase of the case, at the beginning when the jury is trying to determine whether or not he's guilty of the charges against him. This is the only time that he has a burden of proof in the guilt phase. Normally the burden is for the state to prove beyond a reasonable doubt that he's guilty. But in raising the defense of insanity, the defense has to raise it and prove it by clear and convincing evidence. I'm going to give you the definition of insanity. We are going to be asking you some questions about your ability to accept this type of a defense. A person is considered to be insane when he had a mental infirmity, disease, or defect. Because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. There is a long instruction on insanity. I just read you the definition. That's all you need for today's purposes. So the questions are going to be about your feelings about mental illness and about this type of a defense. And then lastly, I have a statement to read you all. On the morning of January 9th, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide, when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire, before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. That last portion I read to you about the conviction for the murder of Ms. Dixon and her child, her unborn child, she was pregnant at the time, cannot be used by you to determine whether or not Mr. Loyd is guilty of these charges. It is a separate case. It would be offered in the penalty phase of these proceedings, and we're going to have some questions for you about this. All right. By show of paddles only, please. How many of you have previously heard about this case? Raise your paddles. When I call your number, you can put them down. 16, 19, 26, 29, 30, 35, 36, 37, 38 or 39, 40, 42, 43, 44, 45, and 48. I'm sorry, 11, I'm sorry. Thank you. Of those of you who raised your paddles, don't say anything, just raise your paddles again. How many of you have formed an opinion as to whether or not Mr. Loyd is guilty? All right, we've got 16? Yeah. 19, 26, 29, 30, 35, 37, 39, 40, 42, 43, 44, and 45. Did I miss anyone? All right. Is there anyone on the panel who has a religious, moral, or personal conviction about the death penalty such that they would never impose death regardless of what the law of the state of Florida is? 36, 30, 36, 37, and 15. Anybody else? All right. Is there anyone on the panel for whom a conviction on the charge of first-degree murder, intentionally killing another person, would result, you are someone who believes that if you are convicted of first-degree murder, you should be sentenced to death? Nothing else going on. All right. 26, 29, 35, 39, 42. Did I miss any? And 14. Okay. All right, folks, thank you very much. I'm going to send you all back into the jury room, juror number 11, if you'll remain in the courtroom. I'll be with you as soon as I can. Please make yourself some coffee if you haven't already. We'll try and get you out of here as soon as possible. Thanks. Coffee's already made.
Sitting there. Thank you.
All right, good morning, ma'am. How are you?
I'm good. How are you?
I'm doing well, thank you. Let me wait till everybody's out of the room. I recognize this may not be the most comfortable situation you've ever been in, but do try to relax as much as you can. I'm going to be asking you some questions. There aren't any right or wrong answers to these questions. The questions are intended to determine whether or not you can do your job as a juror in this type of case. It's information you need to have and we need to have, all right? So the only correct answer is the truth.
Okay.
You have heard about this case prior to this, is that correct?
As a headline, yes.
In a headline?
Like,
all right.
Yeah.
And you said you had formed an opinion as to whether or not Mr. Loyd is guilty?
No, ma'am.
You have not? I thought you raised your paddle to that. Oh, okay. All right, and then in that case, I'm going to send you back in the jury room, okay?
Oh, okay.
I thought you did, and I wrote it down. I'm sorry. All
That's
right,
okay.
we'll get back with you in just a minute. Thanks. If you could send in juror in seat number 16. Thank you. What? Oh, wait. She was death penalty? Yes or no on the death penalty? I don't have her down for any other than, that's all I have. I'll get back to her in a minute. Let me do these, folks. All right, good morning, sir. How are you?
Good.
I'm going to be asking you some questions this morning. There aren't any right or wrong answers to these questions. The questions are meant to determine whether you can do your job as a juror in this case. It's something both you and everyone here needs to know. So the only correct answer is the truth. You follow me? All right. You said that you'd heard about this case. Is that correct? All right. And that you formed an opinion as to whether or not Mr. Loyd is guilty. Is that correct? And what is your opinion?
Guilty.
All right. Jurors have to be required to be able to presume Mr. Loyd is innocent until and if the state proves he's guilty. Can you set that aside, or would you begin the trial believing him to be guilty?
I believe he'd be guilty.
Okay. State.
State moves, Your Honor.
All right. Thank you, sir. You are free to go. The juror in seat number 19, please. All right, the juror in seat number 26, please. Good morning, how are you?
I'm good. How are you?
Just fine, thank you. I just have a few questions for you.
Of course.
There aren't any right or wrong answers to these questions. The questions are designed to determine whether or not you can do your job as a juror in this type of case. We all need to know that, including you.
Of course.
So the only correct answer is the truth. You said that you'd heard about Mr. Loyd's case, is that correct?
That's correct.
And that you had formed an opinion about whether he was guilty or not?
I have.
What is your opinion?
That he is guilty.
In order to sit as a juror in any criminal case, you have to presume the defendant to be innocent until and if the state can prove that he's guilty. Can you do that in this case, or would you start the case presuming him to be guilty?
Honestly, I would probably start the case presuming that he's guilty.
Thank you. State.
State moves.
All right, thank you, ma'am. You are excused. Juror in seat. If 19 is out of the restroom, 19. If not, 29, please. Thank you. All right. Good morning, how are you?
Morning.
All right, sir, I have a few questions for you.
Yes,
No
ma'am.
right or wrong answers, all right?
Okay.
The questions are designed to determine whether or not you can do your job as a juror in this case. It's something you need to know and we need to know. So
Yes, ma'am.
the only correct answer is the truth.
Okay.
All right, you said you'd heard about this case, is that correct?
Yes, ma'am.
And that you had formed an opinion as to whether or not Mr. Loyd is guilty, is that correct?
Yes, ma'am.
And what is your opinion?
Well, from what I heard, I just figured he was guilty from the things that happened.
All right,
But overall, I went from the first case that you said is not going to be discussed, from the girlfriend to the cop. So overall, I made that decision.
all right, so you followed it pretty closely.
Yes, ma'am.
In order to sit as a juror in this type of case, you have to be able to presume Mr. Loyd to be innocent until the state proves him guilty. Can you do that, or would you start the case thinking, I think he's guilty?
No, it'd be interesting to find out, what really happens, because you just got one side of it, and,
Okay.
Just really wasn't sure. But if there's evidence that he's possibly innocent, I would love to hear.
All right, so let me ask you, let me give you 3 scenarios, and you tell me if any one of them applies to you. If they don't, just say that too, okay? Scenario number 1, you're sitting in that chair, it's the first day of the trial, you haven't heard anything, but you're thinking to yourself, he's innocent, and I want to see if the state can prove he's guilty beyond a reasonable doubt. Scenario number 2, you're sitting in that chair and you're thinking, he's probably guilty, but I'll listen to the evidence and see if I change my mind. Scenario number 3, he's guilty, but if he can change my mind, I'm willing to listen. Do any of those 3 apply to you?
Yes, ma'am.
Which one?
Probably number 1.
Number
Mostly,
1, he's innocent and the state has to prove it to you?
Yes, ma'am.
All right. You also indicated to me that you are someone who believes that if you are convicted of first-degree murder, you should automatically be sentenced to death. Is that correct?
No, ma'am.
You didn't raise your paddle for that?
Automatically death?
Yes, sir.
I don't think I raised, I'm not sure. I don't think when it comes to a sentence like that it's automatically death without, hearing the evidence,
All right. So let me put the question to you this way. If you voted guilty of first-degree murder, the intentional killing of another person with no legal justification, all right, would you ever be able to consider a life sentence, or would you think that person deserves the death penalty?
Well, you deserve the death penalty.
Okay, thank you, sir. State.
State moves, Your Honor.
All right. Thank you, sir. We're going to release you from your service in this case. We appreciate it very much. You have a great day.
Okay, thank you, ma'am.
Juror in seat 29, please. No, that was, shoot. 29 is the one I need to talk to. And for the record, I thought I was talking to 29. I was talking to 19. He didn't raise his paddle, but he gave the answer on the death penalty, so. Good morning, ma'am. How are you?
Good, how are you?
I'm well, thank you. All right, a few questions for you this morning. No wrong or right answers to this. The questions are designed to find out whether or not you can do your job as a juror in this type of case. It's something that we all need to know, including you. So the only correct answer is the truth.
Okay.
You indicated that you knew about this case, is that correct?
Yes,
And that you had formed an opinion as to whether or not Mr. Loyd is guilty, is that correct?
yes,
And what is that opinion, ma'am?
guilty.
All right, in order to sit as a juror in this case, you have to be able to presume Mr. Loyd to be innocent until the state proves he's guilty. So would you begin this trial able to do that, or would you begin the trial thinking he's guilty?
I like to think I could.
Okay, but that
Yes.
wasn't really my question.
Yes, I think I could try to be impartial, yes.
Okay, you could try. All right, let me give you 3 scenarios. You tell me if any of them apply to you. Number 1, it's day 1 of the trial. You've heard nothing. You're sitting in that chair. You're waiting for it to begin. You're sitting there thinking, you know, I think he's probably guilty, but I'm willing to listen and see if I'm wrong about that. Number 2, this guy's innocent and the state needs to prove to me that he did it beyond a reasonable doubt. Number 3, I think he's guilty, but if he can convince me otherwise, I'll vote not guilty. Do any of those? Number 1? All right, thank you, ma'am. State.
State moves, Your Honor.
All right, thank you, ma'am. You're free to go. Juror in seat number 30. Good morning. How are you?
Good morning, I'm well. How are you?
I'm well, thank you. Ma'am, I just have a couple questions for you. There are no right or wrong answers to these questions. The questions are designed to determine whether or not you can do your job as a juror in this case. It's something we all need to know, including you. So the only correct answer is the truth.
Okay.
All right. You indicated that you'd heard about this case, is that correct?
That's correct.
And that as a result of that, you formed an opinion as to whether or not Mr. Loyd is guilty.
Yes.
What is your opinion, ma'am?
I believe Mr. Loyd is guilty.
All right. In order to be able to sit as a juror in in any criminal case, you have to presume the defendant to be innocent until the state can prove he's guilty. Do you believe you can do that in this case?
I would have a hard time.
All right. Thank you, ma'am.
Thank you.
State moves for cause, Your Honor.
All right. Thank you, ma'am. You're excused.
Thank you.
Juror in seat 35. Good morning.
Good morning.
I have a few questions for you this morning. There aren't any right or wrong answers to my questions or any questions you're asked by the attorneys. Questions are designed to determine whether or not you could do your job as a juror in this case. It's something you need to know and something we need to know. So the only correct answer is the truth. Let me start with, you told me that you had heard about this case. Is that correct?
Yes.
And that as a result of that, you formed an opinion as to whether or not Mr. Loyd is guilty?
Yes.
What is that opinion, sir?
Guilty.
Right. In order to sit as a juror in any criminal case, you must presume the defendant to be innocent until and if the state can prove he's guilty beyond a reasonable doubt. Could you do that in this case, or would you begin the trial believing Mr. Loyd to be guilty?
I would begin the trial with believing he'd be guilty.
State.
State moves, Your Honor.
All right. Thank you, sir. You're free to go. Juror in seat number 36.
Should I sit?
Good morning, sir.
Good morning.
How are you this morning? All right. Have a few questions for you. There aren't any right or wrong answers to these questions, all right? They're designed to find out whether or not you can do your job as a juror in this case. It's something that we all need to know, including you. So the only correct answer is the truth. Let me start with, you told me that you'd heard about this case, is that correct? And that as a result of that, you formed an opinion as to whether or not Mr. Loyd is guilty? No. You have not? Okay.
You pay attention to local news usually? Is this, I know nothing else about the case.
All right. You also indicated to me that you have a personal, religious, or moral objection to the death penalty.
I do.
Is it, which one of those is it, or is it all of them?
It's moral.
Moral? All right.
Yes.
How long have you held that belief, sir? For decades? All right. So if you were faced with, you've convicted someone of first-degree murder, but now you have to vote life or death, would you ever be able to vote for a death sentence, even if the law said and the facts and the evidence led you to believe that was the appropriate sentence? No. All right. State?
State moves, Your Honor.
All right. Thank you, sir. You're free to go.
Thank you.
Juror in seat 37. Thank you. Good morning, ma'am. How are you?
Good morning, thank you.
I have some questions for you. There's no right or wrong answers to my questions, or to any question you're asked in this courtroom. The point of these questions is to determine whether or not you can do your job as a juror in these types of cases.
Okay.
So it's something we need to know. It's something you need to know. The only correct answer is the truth. You said that you had heard about this case. Is that correct?
Correct.
And that as a result of that, you formed an opinion as to whether or not Mr. Loyd is guilty, correct?
Correct.
What is that opinion?
He's guilty.
All right. In order to sit as a juror in any criminal case, you must be able to presume the defendant to be innocent until the state, and if the state, proves him to be guilty beyond a reasonable doubt. Could you do that in this case, or would you start the trial assuming he's guilty?
I could not.
All right.
State moves for cause.
Thank you, ma'am. You're free to go. Juror in seat 39, please. Good morning, sir. How are you?
Good, and you, thank you.
I'm fine, thank you. Sir, I have some questions for you this morning. There aren't any right or wrong answers to my questions. The questions are designed to determine whether or not you can do your job as a juror in these types of cases. We need to know that, you need to know that, so the only correct answer is the truth, okay? You said you'd heard about this case, correct? And that you'd formed an opinion as to whether or not Mr. Loyd is guilty?
No.
You have not formed an opinion as to
No, I
his
don't have
guilt?
an opinion.
All right. How much did you hear about the case?
Not a lot. I hear just when it happened, but I never followed the case like on a daily basis.
All right. You also indicated to me, if my notes are correct, and they may not be, that you are someone who believes that if a person is convicted of first-degree murder, the intentional killing of another human being, that person should be sentenced to death. Is that correct?
That's correct.
All right. So in a case like this, you have to be able to consider both sentences, life or death. So if there was a conviction for first-degree murder in this case, and let me add to that first-degree murder of a law enforcement officer, would you be able to consider life, or would your vote be for death?
I will consider life.
You would consider life?
Yes.
Can you tell me, you just told me you believe that death should be the sentence, so tell me,
Well, it's
explain
just-
that to me.
It's just based on I believe that someone that takes someone's life should not be.
You got to get that mic closer to you. I'm having trouble hearing you.
I would consider just depending on what was the case, like mentally or just something like that, why he committed the crime.
Okay.
If he was mentally stable or not.
So let me go into a little bit more detail with you about this. You've convicted someone of first-degree murder, intentionally killing another person with no legal justification, meaning it's not self-defense, it's not insanity, all of that's been rejected. The state's proven guilt beyond a reasonable doubt because you can't convict without that. Are you with me so far?
Yes.
All right, now you're in a penalty phase. The state's going to put on evidence of aggravators, the reasons they believe death is the appropriate sentence. The defense is going to put on mitigators, the reasons they believe life in prison without the possibility of parole is the appropriate sentence.
I would just consider the penalty.
You would just consider
Yes.
the death penalty? All right, state,
State moves, Your Honor.
defense. All right, thank you, sir. You're free to go. Juror in seat number 40. Good morning, sir. How are you?
Good morning.
All right. I have some questions for you. There aren't any right or wrong answers to my questions or any question you're asked in this courtroom. The questions are designed to determine whether you can do your job as a juror in this type of case. So it's something that we need to know, you need to know it. The only correct answer is the truth, okay?
Okay.
You've heard about this case, correct?
I have.
And you've formed an opinion as to whether or not Mr. Loyd is guilty?
I have.
What is that opinion?
I believe he's guilty.
All right. In order to sit as a juror in any criminal case, you must be able to presume the defendant to be innocent until and if the state proves he's guilty. Is that something you could do in this case, or would you begin the trial believing Mr. Loyd to be guilty?
I believe I could do that.
Okay. So I'm going to give you 3 scenarios. You tell me which one applies to you.
Okay.
Scenario number 1, and if none of them do, tell me that, okay?
Okay.
Scenario number 1, it's the first day of the trial. You're just sitting here waiting for the trial to start. You haven't heard anything. In your mind, you're thinking, I think this man is innocent and the state needs to prove to me he's guilty beyond a reasonable doubt. Scenario number 2, you're thinking, I think he's probably guilty, but I'm willing to listen and see if I'm wrong and that, they can't prove it. Scenario number 3, I think he's guilty, but if he can convince me otherwise, I'm willing to listen. Do any apply to you?
Probably 2.
Number 2? All right, thank you, sir. State.
State moves, Your Honor.
All right, sir, thank you very much. You're excused.
Thank you.
Juror in seat number 42. Just have a seat, sir. Good morning. How are you?
Good morning. Great. Thanks.
All right, I have some questions for you. There aren't any right or wrong answers to my questions. The questions are designed to determine whether or not you can do your job as a juror in this type of case. It's something we all need to know, including you. So the only correct answer is the truth. All right. You told me that you'd heard about this case. Is that correct?
Yes, ma'am.
And that you had made a decision as to whether or not Mr. Loyd is guilty, or had an opinion as to whether or not Mr. Loyd is guilty.
Yes, ma'am.
What is that opinion?
Just that. I'm not sure I understand the question.
All right. Do you believe Mr. Loyd is guilty?
Yes.
Okay. So in order to be able to sit as a juror in any criminal case, you have to be able to presume someone to be innocent until the state proves they're guilty. Is that something you could do, or would you start the trial believing he's guilty?
Yeah, unfortunately, I think my opinion's already what it is.
All right. Thank you, sir.
State moves.
All right. Thank you, sir. You're excused. Juror in seat 43, please. Have a seat, sir. Good morning, sir. How are you?
Good.
All right, I have a few questions for you. There aren't any right or wrong answers to my questions. The questions are designed to determine whether or not you can do your job as a juror in this type of case. It's something we all need to know, including you. And so the only correct answer is the truth, all right? You said you'd heard about this case, is that correct?
Yes.
And that you'd formed an opinion as to whether or not Mr. Loyd was guilty. What is that opinion, sir?
He is guilty.
All right, in order to sit as a juror in any criminal case, you must be able to put aside any opinions and presume someone to be innocent until and if the state proves them to be guilty. Do you believe you could do that, or would you start the trial assuming Mr. Loyd is guilty?
The trial assuming he was guilty.
All right, thank you, sir.
State moved, Your Honor.
Thank you, sir. You are free to go.
Thank you.
Juror in seat number 44. Good morning, sir. How are you?
Good, how are you?
I'm well, thank you. I have a few questions for you. There aren't any right or wrong answers to these questions. The questions are designed to determine whether or not you can do your job as a juror in these types of cases. We all need to know that, including you. So the only correct answer is the truth. You said you knew something about this case, is that correct?
Yes,
And that based on that, you'd formed an opinion as to whether or not Mr. Loyd was guilty?
correct.
And what is that opinion?
That he would be guilty.
All right. In order to sit as a juror in a criminal case of any kind, you must be able to presume the defendant to be innocent until and if the state proves he's guilty. Is that something you could do in this case, or would you begin the trial assuming Mr. Loyd was guilty?
I would have a difficult time.
All right. Thank you, sir.
State moved, Your Honor.
Sir, you are excused. You're free to go. Thank you so much.
Thank you.
Juror in seat number 45. Good morning.
Good morning.
How are you this morning?
Good. You?
I'm well, thank you. Ma'am, I just have a few questions for you
Okay.
right now. There aren't any right or wrong answers to my questions. The questions are designed to determine whether or not you can do your job as a juror in this type of case. So the only correct answer is the truth.
Okay.
You indicated that you'd heard about this case, is that right?
That's correct.
And that you had formed an opinion based on that as to whether or not Mr. Loyd is guilty. What is that opinion?
I feel he could be guilty.
Okay. You must be able to presume someone to be innocent in any criminal case until and if the state proves they're guilty beyond a reasonable doubt. Can you do that in this case, or would you start the trial assuming he's guilty?
That's hard for me to answer because I try to look at everything critically. The media, of course, has given a lot of information on the case, so that makes it more difficult to presume he's innocent when I've already heard about the other case.
All right. So let me give you three scenarios. You tell me which one it applies to you. Number
Okay.
one, it's the first day of the trial. You have heard nothing. You're just sitting there waiting to start. In your mind, you're thinking, this man is innocent and the state needs to prove to me he's guilty. That's one. Number two, you're sitting there thinking, he's probably guilty, but I'm willing to listen and see if the state can prove it. Number three, I think he's guilty, but I'm willing to listen and see if I'm wrong.
I would say 2.
2? All right. Thank you, ma'am. State.
State moved, Your Honor.
All right, ma'am, you are excused. You have a great day. Thank you for coming today. All right. Juror in seat number 14, please. Good morning, sir. How are you?
Good.
All right, I have some questions for you. this morning, and then the attorneys may have some questions for you. There aren't any right or wrong answers to the questions, right? The point of these questions, the reason we're asking them, is to try and determine whether or not you can do your job as a juror in this type of case. It's something we all need to know, including you. So the only correct answer is the truth. We good? All right. So let me start by asking you this. You didn't indicate you'd heard anything about this case, is that correct? I can barely hear you. All right. Not initially? What does that mean?
I didn't hear about it until I had to travel back to my dad's house. And he may have mentioned a little bit, but I didn't really pay attention.
Again, I can't hear you. I'm sorry. Yeah. Go ahead and take the mask off. All right. Go ahead. That mic goes in and out. It's not you.
Oh.
Okay. Thanks.
Having to travel down to my dad's house I've heard maybe a couple sentences about it from my dad.
Okay. Is anything that your dad said to you cause you to reach an opinion as to whether or not Mr. Loyd is guilty?
Yeah, mentioned a couple things.
Okay. What couple things did he mention? Yeah, you guys just got to hold it in one spot.
Okay. My dad did mention that he watches the news, so he knows about it, and that he killed all those people or killed those couple people. That's what I've heard before I even got picked as a juror.
Okay. You're not going to get anybody in trouble by
Yeah,
answering these questions. Your dad's not getting in trouble. You're not getting in trouble. We just need to know what you've heard prior to coming in here. So based on what your dad said, did you make any assumptions about whether or not Mr. Loyd's guilty? It's okay. You can say it. Yeah.
I feel if you killed 7, 8, 9, or however many people, then I feel like you're guilty, yes.
Okay. Let me start with telling you that he's not charged with killing 7, 8, or 9
I
people.
know.
He's charged with killing one person, Lieutenant Clayton. You understand that?
Yes,
All
ma'am.
right. So let me ask you this question. I think my notes say that you raised your paddle when I asked if that you believe that if someone is convicted of first-degree murder, intentionally killing someone, they should be sentenced to death. Is that correct?
Yes.
All right. In these types of cases, you have to be able to consider a life sentence. So my question is, and remember what I told you, the only correct answer is the truth. My question to you is this. If you found Mr. Loyd guilty of first-degree murder, intentionally killing another person, and in this case, the person would be a law enforcement officer, would you be able to consider life in prison, or would you vote for death?
I would probably vote for death.
All right. Thank you. State.
State moves, Your Honor.
All right. Thank you, sir. You're excused. Juror in seat 15, please. This is ridiculous. Are there the other two that were missing? Yeah, bring them up because there's not going to be anybody left. All right. Good morning, ma'am. How are you?
Good morning. Good. How are you?
I'm well, thank you. I have a few questions for you. The attorneys may have some questions for you also. There aren't any right or wrong answers to these questions, all right? The point of the questions is to try and find out if you could do your job as a juror in this type of case. So the only correct answer is the truth, all right? So you indicated that you are someone who has a moral, religious, or personal objection to the death penalty. Is that correct?
Yeah.
And which one is it?
I guess personal. More.
Okay, how long have you held that belief?
Hard to say, but Probably a while.
All right. And is your belief so strong that if someone was convicted of first-degree murder, you would never consider the death penalty, no matter what the facts, circumstances, or law was? You would always vote for life?
Yeah.
Which one? Yes, you would?
Yes, I would always vote for life.
Okay, thank you. State.
State moves, Your Honor.
All right, thank you, ma'am. You are free to go.
Thank you.
Okay. Let's bring in the juror in seat number 48, please. The two missing jurors have arrived, so I show we have 9, 11, 48, 21. That's it. All right. Good morning, sir. How are you?
Good, Your Honor. I'm fine, thank you.
I just have a few questions for you, and then the attorneys may have some questions for you. There aren't any right or wrong answers to these questions. The point of the questions is to determine whether or not you can do your job as a juror in this type of case. It's something we all need to know, including you. So the only correct answer is the truth. You said you'd heard about this case, is that correct? How much have you heard about it?
It was in the news back at the time. But
You talking about when it happened?
when it happened, yeah.
All right. How much of that coverage did you watch?
Just a little. I don't watch news much.
Okay. Do you read the paper?
I read parts of the Sentinel, and most of my news is on my Apple News on my iPad.
All right. And anything that you saw on your iPad in the Capitol News about this case?
Lately, the only thing I saw was that jury selection was coming.
Did you talk to friends or family or coworkers about the case?
No.
Even when it was happening? I'm not talking about now.
No. Like local news or things like that, so she would be the only one I would talk to about it. But
All right. So based on what you saw or read or heard, did you form any opinion as to whether or not Mr. Loyd was guilty?
at the time, it did seem like that's what they were saying. But this time, I have an open mind.
All right, let me give you 3 scenarios, and you tell me if any one of them applies to you, all right? Scenario number 1, it's the first day of the trial. You're sitting there as a juror. You have heard nothing. You're just waiting for it to start. And in your mind, are you thinking, this gentleman is innocent, and I'm waiting to see if the state can prove he's guilty beyond a reasonable doubt? Number 2, hold on. Number 2, you're sitting there thinking, he's probably guilty, but I'm willing to listen to the case and see if I'm right about that. Number 3, I think he's guilty, but if he can convince me otherwise, I'll vote not guilty. Do any of those apply to you? Which one?
Number 1.
Number 1? Okay. So, are you a person who has any personal, religious, or moral convictions against the death penalty?
No.
Are you someone who believes that if someone is convicted of first-degree murder, the intentional killing of another person with no legal reason to do so, that they should be sentenced to death?
No.
If I add to that last question I just asked you about first-degree murder, the fact that the person was a police officer, does your answer change? Okay. And then my last question as to this fact, just the first-degree murder. If the person had previously been convicted of murder, does your answer change?
No.
All right. You heard me describe to you what the process is for listening to the evidence at the penalty phase, evaluating the evidence, weighing the factors, and then coming to a decision. Do you believe that you would be able to do that with an open mind towards both sides?
Yes, I would.
Right. And if that process led you to believe that the appropriate sentence was life without the possibility of parole, would you be able to vote for that?
Yes.
And if it led you to believe that the appropriate sentence was death, would you be able to vote for that?
Yes.
switching gears a little bit, you heard me tell you that Mr. Loyd has raised the defense of insanity. And that would be in the guilt phase, when you're trying to decide whether or not he's guilty. The defense has to prove it. But if at the end of the case, of the guilt phase, the state's put on all their evidence, the defense has put on all their evidence, you are convinced by the defense's evidence that Mr. Loyd was insane at the time of the offense, would you be able to return a verdict of not guilty by reason of insanity?
Yes, I think so.
And then my last question to you is, as I told you, he's been previously convicted of the murder of Miss Dixon and her unborn child and is serving life for that. Would you be able to put that out of your mind when you're trying to decide whether he's guilty of these charges?
Yes, I would.
It can be considered in penalty phase, but it can't be considered in guilt. Do you have any doubts about any of this?
No, ma'am.
All right, thank you, sir. I'm going to turn this over to the lawyers. Mr. Buxman, you may inquire.
Thank you, Your Honor.
Morning, sir.
Morning.
I noticed from your questionnaire you've been a juror before.
Yes, I have, twice.
Twice. Lucky guy, huh? When was the last time?
It was a few years ago, maybe 2017 or 2018, I don't remember the exact date.
Was that here in Orange?
It was here.
Okay, and how long was the one prior to that?
It was in 2013 here.
Okay. Were those cases civil or criminal cases?
The first one was a civil case. It was a medical negligence case, a private trial. The second one was, I think it was a misdemeanor criminal trial.
Okay. Without telling me the verdicts you reached in either of those, were you able to reach a verdict?
Yes.
And were you the I'm sorry.
Well, on the second case, I turned out to be the alternate juror, and I was dismissed before they went to the jury room.
Understood. On the first case, did you happen to be the foreperson of the verdict, of the jury?
No.
Okay. Is there anything about either one of those experiences that just makes you not want to do this process again?
No.
Okay. I also saw from your questionnaire you served in the Navy.
Yes, I did.
Thank you, sir, for your service. How long did you spend in the Navy?
I was both active duty, in reserves, and civil service. So my whole 30-year career working was either active duty, reserve and recalled to active duty, and civil service. So.
Okay. The first couple questions I have for you deals with the insanity defense that the judge was talking about a few minutes ago. And that is something that will be addressed in the guilt phase of the trial, the portion of the trial that's meant to determine if Mr. Loyd is guilty of the crime. The judge asked you if you would be able, you listened to the evidence and the defense was able to prove to you that insanity was a viable defense in this case, would you be able to find the defendant not guilty by reason of insanity? I think you said, I think so. We listened to the words, and the words, I think so. Can you tell me what was going through your mind when you said that?
I don't know a lot about insanity defenses, so I would want to listen to both sides and before I could come up with an opinion. But if the person was really, prove that it was insanity, I would be able to vote that way.
Okay. The next set of questions I have for you deals with if we get to a sentencing phase or a penalty phase. So these questions presume that the jury has already listened to the guilt phase of the trial, and you've determined that the defendant is guilty beyond a reasonable doubt of the crime of first-degree murder. The jury has analyzed the evidence, found him guilty. They've rejected any defenses, including sanity. Okay? Now we're into the penalty phase portion, where the whole purpose of this portion of the trial is to determine what the proper punishment should be, either life in prison or death. The focus of these questions is really looking to see whether you are able, as a juror, to keep an open mind and listen to all of the evidence. So in that penalty phase process, the state will introduce evidence of aggravating factors, which are factors that make this murder worse or more egregious than other murders. And the judge mentioned a couple of them to you already. One of an aggravating factor is that the victim in this case was a law enforcement officer. And if proven, that is something that you can use that could be used by you to justify a sentence of death if you felt that was wrong. So another aggravating factor the judge mentioned to you, you heard about a prior murder conviction that the defendant has. Now, she said you can't use that in the first part of the trial to determine if he's guilty or not of these crimes. But if you find him guilty, it could become relevant in the second sentencing phase of this trial. So my question really is, if you're sitting there listening in the sentencing phase and you hear and you find that the aggravating factor that the victim was a law enforcement officer was proven, that may start swinging your pendulum a little towards a decision of death. Could have swung it a lot, depending on how much weight or importance you give that. And then if you heard that the defendant had a prior murder, that again might continue to swing your pendulum towards the death penalty in your mind. No matter how far your pendulum swings towards the death penalty, would you be able to always listen to the mitigating evidence presented by the defense? Evidence about the defendant's background, character, his life, before making a final decision of what the proper punishment should be?
Yes.
Can you do that regardless of whether at first blush a mitigating circumstance is presented to you, and at first blush you may be thinking, I don't know if that's real.
Overruled.
Would you be able to consider that mitigation, even if at first blush, when you first hear it, first thought of your mind might be, I don't know if that's important. I don't think that's mitigation. Can you hold off judgment until you hear all the details and the evidence surrounding that piece of mitigation?
That happened in my first trial. You hear the evidence from the plaintiff in the defense, and your mind keeps on considering all the different facts, and at the end you come up with a decision.
Because this is not the time for us to talk about the actual facts and the details and the evidence you're going to hear relating to the aggravating factors and the mitigating circumstance. That's during the trial. So my question for you is, no matter what piece of evidence is presented to you as mitigating evidence or evidence that might make a life sentence the proper punishment in this case, can you listen to it?
Yes.
Can you truly listen to it, consider it, mull it over in your mind, think of the details and the pieces and the facts that go along with that evidence before you make a final decision?
I think that when you listen to all of it, you keep on forming a little bit as you go along, but at the end you have to consider all of it before you make your decision. I can do that.
Okay. So you agree Mr. Loyd deserves to have a jury who remains open-minded until all the evidence is in?
Yes, I do.
If after weighing all of that evidence, you're back in the jury room and you're thinking, I think life is the proper punishment in this case, could you vote for that?
Repeat the question?
Sure. After you hear all the evidence that's presented to you and you've considered it all and you're back in the jury room and you're thinking that I think life is the proper punishment in this case, could you vote for that?
Yes.
On the flip side of the coin, if you felt that death was the proper punishment, after considering everything, could you come back in this courtroom and vote for that as well?
Yes, I could.
The last question for you. Is there anything in your background, your experiences, your belief system that may make you not a good juror for this type of a case, considering we're trying to find fair and impartial?
No, there's...
Thank you so much for your time, sir. No further questions, Your Honor.
Thank you, Mr. Buckman. Miller, you may inquire.
Good morning.
Good morning.
How are you, sir?
Good, thank you.
A little sleepy. I want to just touch a little bit more on when the judge was asking you at the very beginning about what you had seen on the news, right, about Mr. Loyd's case. I think you said it seems like that's what they are saying about Mr. Loyd being guilty, correct?
I don't recall those exact words, but the news is reporting what was in the news, but that is, to me, is not evidence.
Okay, and that's what the lovely transcriptionist wrote down. So do you have any reason to think I'm wrong in saying it seems like that's what they are saying as to his guilt was your answer?
Repeat those words.
Do you have any reason to think that's not what you said?
I'm trying to understand what you're saying I said.
The judge asked what you knew
Yes.
in the media about Mr. Loyd, and then she asked if you had an opinion as to whether or not he was guilty. And I believe your answer was, it seems like that's what they are saying.
Okay.
And so I don't think anyone is questioning your duty or willing to serve. Obviously, you're a career service person. The question, though, is, based on that information that you have, do you have a nagging feeling that Mr. Loyd is guilty?
No, I have an open mind.
You understand that he's been indicted for some very serious crimes.
Yes.
Is the fact that he's been indicted for those charges, does that mean he must have done them?
No, it doesn't.
Okay. Tell me more about that, if you don't mind.
The judge said that an indictment is just an accusation. It is not evidence in a court of in the trial. You have to listen to the evidence before you come up with a decision whether or not somebody is guilty or not.
Okay. And that's where, absolutely, if you are selected as a juror, all of those rules apply. Right? The only oath you've taken right now is a prospective juror. Still
Yes.
right? And some people's feelings differ on these sort of things, right? And I'm certain all of us want to believe or try to follow the law, right?
Yes.
Okay. When the judge initially asked you if you could impose life without the possibility of parole for somebody who committed the intentional, premeditated murder of a law enforcement officer, thought about it, meant to do it, and did it, it appeared to me you hesitated before answering that.
I think you have to listen to all the facts before you can really come up with a decision on that. I think a person, whether or not if somebody kills somebody, you have to listen to the circumstances and all the factors involved in it before you can say one sentence or the other, whether it would be life without parole or the death penalty.
Okay. And I just want to make sure we're not talking about things that may or may not make someone guilty. So when you say the circumstances, what are you talking about?
Well, if we're talking about the penalty phase,
yes, sir.
We're talking about the aggravators and the mitigators.
Okay.
Those are the circumstances.
I gotcha. One of the mitigating circumstances you may hear about is the effects of racism on Mr. Loyd. Do you think you could give meaningful consideration? And when I say meaningful consideration, I mean hear it, internalize it, and it could potentially affect the outcome, right? Meaningful consideration doesn't mean I heard it and dismissed it sort of simultaneously. You know what I mean?
Yes.
So do you think you could give meaningful consideration to something like the effects of racism for a person who killed in an intentionally premeditated manner a law enforcement officer?
Yes.
Okay. We talk about insanity, right, and finding someone not guilty by reason of insanity because it's kind of a threshold issue. If Mr. Loyd was charged with theft, it probably wouldn't be that hard to imagine finding him not guilty by reason of insanity. But he's charged with the murder of a law enforcement officer. And so some people say to me, not guilty by reason of insanity is not guilty. It's him saying, I did this, but I was insane at the time. Does that make sense? And some people say, I would not be able to find someone not guilty by reason of insanity for a charge like the intentional premeditated killing of a law enforcement officer. Does that make sense?
Yes.
Tell me where you fall in that.
I'm going to object to suggesting there's a different standard depending on the crime.
I think people have differing feelings.
No, sustained. Rephrase the question.
Tell me what your thoughts are, please.
That's not rephrasing the question. Ask a different question. Go ahead.
Do you think you could find someone not guilty by reason of insanity for the crime of the intentional premeditated killing of a law enforcement officer?
Yes.
How come?
Whether or not the victim in the case is a police officer or not doesn't mean that they would not be insane at the time of the crime was committed or the killing was committed.
Okay. How about just murder generally?
Some people can be insane when they do kill people.
Okay. And so you believe that is a valid defense to the crime of murder?
Yes.
I apologize, just taking notes so I don't forget anything. You would probably not be surprised to learn that folks have differing opinions on these sort of things. Fair?
Yes.
And that death is never required, not in any case, not in the worst imaginable case you can conceive of, okay? And so if we get to the penalty phase, right, we may never get there. In order to get to the penalty phase, the state would have to prove Mr. Loyd guilty, and we would have to fail to prove him not guilty by reason of insanity. With me?
Yes.
So if we're in the penalty phase, the state has to prove the existence of at least one aggravating factor, that aggravating factor is sufficient to warrant the death penalty, that the aggravating factors outweigh the mitigating circumstances, and then the last question is death the appropriate penalty in this case? And that last question is never required, the answer is never required to be yes. Does that make sense?
Yes.
Even if everything else is yes, 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 you can still say no. With me?
Yes.
And that in order for a just verdict to be returned in this case, all 12 jurors' individual moral assessments about whether Mr. Loyd lives or dies have to be heard in this courtroom. With me?
Yes.
It would be a miscarriage of justice if not all 12 individual moral assessments about life or death weren't reflected on the verdict.
Yes,
And so certainly you're not going to bully or badger anybody to agree with you who has a differing opinion, right?
Right.
And you wouldn't expect anyone to do that to you.
Correct.
May I have just a moment, Your Honor?
Yes, ma'am. All right, other side need to approach?
No, Your Honor.
Yes, Your Honor.
We'll be with you in 1 second, sir. All right, sir. We are going to send you to a final round of questioning in this case, and that is the day we're going to pick the jury at that final round. So several things are going to happen right now. Number one, I'm switching you to a purple. Oh, you've given your badge to the deputy. Okay. We're going to put a purple dot on your badge. Purple is the final group. As I told you, we call the groups in by color because there's too many people to call them by number. So starting tomorrow, after 5, we're giving you a packet. It's got a slip of paper in there that has a phone number for you to call. Don't call until tomorrow after 5. Honestly, I don't believe we're going to call you in on Friday. It's a slim possibility. Next week is probably when we're going to do this. You'll be called, you're listening for them to say the purple group return at such and such a date and time. That is the day we're going to choose the jury. It's the day we're going to sequester the jury. So when you come back, you're going to need to have packed a suitcase. Just leave it in your car. If you need it because you're picked for the jury, it'll be retrieved. If not, obviously you can just go home. There's also in that packet a sequestration packet that goes over in more detail what it's like to be sequestered and what the rules are, and gives you a suggested list of things to pack. And lastly, we have for you a letter for your employer if you need it. I think you're retired, but any questions?
If I bring my car and I'm sequestered, then my car needs to go back home so my wife can drive it.
Okay.
Can I take a Uber here or something and have a place to drop my bag off?
We'll make arrangements for you. We have a couple of people doing that. So, yes, sir.
Okay.
All right.
Thank you.
Any other questions?
No, ma'am.
Thank you so much. Have a great day.
Thank you.
All right, bring me juror in seat number 11, please. That will leave 9 and 21 back there. They haven't been instructed, so I'm going to bring them both in together when we're done with 11.
Thank you.
All right, I bet you thought I'd never bring you back.
Oh, I was wondering if you forgot about me.
I did not. Welcome back.
Thank you.
All right, same rules apply. Only correct answer is the truth. Can you tell, you said you never heard anything about the case, correct?
Only headlines. Like, I've heard his name, but I only watch the news for, like, hurricanes and...
Okay. And have you formed any opinion as to whether or not he's guilty?
No, ma'am.
So can you presume him to be innocent until and if the state proves he's guilty?
what we're supposed to do in this. Yes, ma'am. That's what I've been taught. So, yes,
All
ma'am.
right, do you have some doubts about that?
No, ma'am.
All right.
I just didn't want to talk too much.
Okay. Do you have an opinion about the death penalty?
I don't have an opinion about the death penalty.
All right. Are you someone who has any religious, moral, or personal objections to it?
No, ma'am.
Are you someone who believes that if a person is convicted of first-degree murder, intentionally killing another person with no legal reason for doing so, for example, it wasn't self-defense, it wasn't insanity, you just killed them, that person should be sentenced to death?
Not necessarily, ma'am.
All right. You heard me describe to you the process that a jury goes through.
Yes.
Number one, there has to be a conviction for first-degree murder, intentionally killing someone, before you even get to a penalty phase. But pretend for right now you're in a penalty phase. Your job is to listen to the state present their aggravators, the defense present their mitigators. You have to have an open mind. You can't be sitting there thinking, okay, I'll listen, and then I'm going to vote the way I was going to vote anyway. You have to be able to absorb the information, sort of process it. You're going back into the jury room to weigh those aggravators and mitigators. Can you go through that process with a fair and open mind?
Yes, ma'am. As long as I can write everything down so I can remember it all. Yes.
Okay. You're allowed to take notes during the trial.
Okay. Like, my memory's not always the best, but as long as I can.
All right. And then now it's time to vote. You've gone through the process, and remember, this is an individual vote. It's your decision alone. If that process leads you to believe that life without parole is the appropriate sentence, could you vote for that?
Yes, ma'am.
If that process leads you to believe that death is the appropriate sentence, could you vote for that?
Yes, ma'am.
All right. Mr. Loyd has raised the insanity defense. That would occur in the guilt phase, when you're trying to decide whether he's guilty or not.
Okay.
Right? It's the only time the defense has to prove something in the guilt phase. It's their burden to raise it and their burden to prove it by clear and convincing evidence. So pretend it's the end of the guilt phase. You've heard all the state's evidence. You've heard all the defense's evidence. The defense has convinced you that Mr. Loyd was insane at the time of the offense. Would you be able to return a verdict of not guilty by reason of insanity?
Yes, ma'am.
And then my last question is, as I told you, he was previously convicted of the murder of Miss Dixon and her unborn child. You cannot use that to determine whether or not he's guilty of these charges. It's a separate case. Can you follow that instruction?
Yes, ma'am.
It can be considered in penalty phase, but not in guilt.
Yes, ma'am.
All right. Thank you, ma'am. The lawyers have some questions for you. Mr. Buxman, you may inquire.
Thank you.
Good morning, ma'am.
Good morning.
I noticed from your jury questionnaire you indicated that you had a friend or a family member in law enforcement.
Two of my cousins.
Two of your cousins?
Mm-hmm.
Okay.
Are they local?
No.
Okay, where are they located?
Southern Illinois.
Illinois?
Mm-hmm.
How long have they been in law enforcement?
I'm embarrassed to say that I'm not close enough with them to be able to answer that. My older one, since I met him, because he married my cousin, so at least 30 years, and then my other cousin is younger than me, and I don't know. I'm sorry.
No, that's fine.
I'm a bad relative.
Knowing that this case involves the murder of a law enforcement officer, would the fact that you have even some distant family members, I guess you could say, in law enforcement, would that affect your decision in this case in any way?
I don't think so.
First couple questions I have deal with the insanity defense that I mentioned earlier.
Okay.
That is something that's going to be addressed in the guilt phase, the first part of this trial, the part of the trial that's designed to determine whether Mr. Loyd is guilty of the crime charged. Because insanity involves potential mental health issues, I have a couple personal questions for you, and I apologize for asking.
That's okay.
But do you or a close friend or a family member have any experience or involvement with mental health issues that have affected?
Personal, no.
Okay.
I was a psychology major, so I am familiar with mental health issues, but no.
Okay. Have you done did you follow up as being a psychology major and work in that field at all?
Oh, no. I became a stay-at-home mom.
Okay. Would you be able to keep an open mind and listen to all of the evidence about whether a mental health issue exists in this case? And if it does, what the effect of it is before you make a final decision as far as whether the defense has proven the defense of insanity to you?
Yes, sir.
Great. Shifting gears a little bit, moving into the penalty phase of this case, if we get that far. For the purpose of these questions, I want to ask you to assume that the jury as a whole has found the defendant guilty beyond any reasonable doubt of first-degree murder.
Okay.
Okay. They rejected the insanity defense, any other potential defenses, and they found him guilty beyond a reasonable doubt of this crime. We're now into the second phase of the trial, the penalty phase, where the purpose of that is to determine what the proper punishment should be, life or death. Okay? In that phase, as the judge indicated, the state will present evidence of aggravating factors to you, which are factors that make this murder more egregious or worse than other murders.
Okay.
Make sense? The judge has alluded to a couple potential aggravating factors you may have heard about, one of which is that the victim was a law enforcement officer. Another of which is that the defendant has been convicted of a prior murder, the murder of his girlfriend. Now, she told you can't consider that prior murder over here in the guilt phase. That's not proper. If we get to the penalty phase, then it could become relevant in your decision.
Okay.
Does that make sense?
Yes, it's a lot, but yes.
It is. There's a lot of stuff thrown at you right away. So do you understand the separation? Those two
I
different
do
purposes?
understand that there are two separate things.
As the state presents to you evidence of
These aggravating factors, your decision-making pendulum may start swinging. You hear she's a law enforcement officer, you hear about a prior murder, that may start swinging towards
the death penalty being your decision. The question I really have for you is, no matter how far this pendulum swings towards your decision of the death penalty, can you hold off making a final decision until you listen and consider the evidence of the mitigating factors, the factors presented by the defense
that focus on the defendant's
character, life, experiences, upbringing, things like that?
I think so. You have to weigh every possibility before you make a decision in everything.
So can you keep an open mind and consider those mitigating factors before you make the final decision, because those mitigating factors may cause your pendulum to swing?
I think so.
Okay. They may not, but they may. Okay.
As of right now, yes, I would say I could. So I guess.
This is not the time to discuss the facts or the details or the evidence you're going to hear about the individual aggravating factors or the mitigating factors. That's during the trial.
Yeah.
Would you be able to keep that open mind and truly consider any mitigating evidence? And by truly consider, I mean not just listen to it and brush it off and do what you're going to do. Truly listen to it, think about the evidence, think about the facts and details, mull it up and then make a decision on whether it's proven?
I think I could, yes.
Okay. And then if you find it's proven, you need to make a decision of, is it important to your decision? You could give it a little weight, you could give it a whole lot of weight or importance. Depends on you. Can you do that?
Yes.
Okay. And can you do that even if you first are thrown a mitigating factor at you? Even if your first thought is, oh, gee, I don't think that's mitigating. Can you hold off until you hear the actual details about that fact?
Yes.
Okay. If I stood up here and mentioned 100 different possible mitigating factors you may hear, would your answer always be the same of, I would listen to it, I would truly consider it before I make a final decision?
Yes.
Excellent. Now, if that, after going through that process of talking, listening, and considering the evidence of the aggravating factors and the mitigating circumstances, and weighing them, if you're back in that jury room and you think that life in prison is the appropriate punishment, could you come back in this courtroom and vote that way?
Yes.
All right. If, on the flip side of that coin, if you did that process and you determined that death was the proper punishment in this case, not talking hypothetically, hanging out with friends, family members, but putting yourself in that situation, looking inside your heart, if you felt that was the proper punishment, could you raise your hand and vote that the death penalty is the proper punishment for another human being?
Yes.
Okay. Last question for you. Is there anything in your background, your life, your belief system that may make you not the best juror for this type of a case?
I don't think so.
Great.
I had a pretty boring existence.
Thank you so much for your time, ma'am.
Thank you.
Thank you, Your Honor. No further questions.
Thank you, Mr. Bruxman. Ms. Miller, you may inquire.
Whoops. No, it's a jungle. It's a jungle back there. Good morning.
Good morning.
You work at the Y, yes?
Yes.
When did you start working there?
7 years ago, so Math.
2014?
I just had my 7-year anniversary a couple months ago, so I will trust your math.
Like it is 2021,
I
right?
need to use my fingers.
Okay.
I think.
And I think you probably get where this line of questioning is going, just a couple follow-up questions.
Sure.
There are some folks that say if it's the intentional premeditated killing of a law enforcement officer, right? So that defendant thought about it, meant to do it, and did it without any legal justification, excuse, or defense. That if that person is guilty beyond a reasonable doubt of that crime, death is really the only appropriate penalty. What are your thoughts on that?
I think everybody has their own opinion, and I think it's really dependent on the circumstances that are given to you and the evidence that's presented.
Okay. And I just want to make sure we're not talking about something like circumstances that would make someone guilty or not guilty. When you say circumstances, what do you mean?
I mean the evidence that's provided to you to judge or compare, contrast. I don't remember what the circumstances were, the aggravated, whatever, the two sides.
Okay, the aggravators and the mitigators.
Mitigators, sorry.
Right, aggravators are things that might make you think death is more appropriate. Mitigators are anything from the defendant's life, experience, or background, but it can also include anything from the state's case, right? So you may hear something from the state's case in chief and think, I find that to be mitigating. And all that means mitigation is why one person would choose life, not choose death.
Okay.
We use it as a legal term, but it's not as fancy, I think, as we make it sound. You also heard that Mr. Loyd has been previously convicted of the murder of Sade Dixon when she was pregnant.
Yes, the judge said that this morning.
Yeah, judge talked about it, and he is serving a life sentence for that.
Okay.
And I don't think you have to be a parent to be more sensitive to the death of a pregnant woman, but some of us as moms are particularly sensitive to that. And since you mentioned leaving your career, tell me what your thoughts are on that.
Well, you said that they have to be judged completely separately, and they could only be taken into account in the penalty phase?
Yes, ma'am.
So,
Sorry,
I was just going to say that would just be the only place that it would come into, I don't know what the right word is.
Sure.
Any reason to need to use that information, I guess.
Sure. And let me maybe rephrase the question more specifically. The judge has said you can't decide if Mr. Loyd is guilty of this case based on that conviction, right?
Correct.
This is a totally separate case. Because he did that doesn't mean he did this, right?
Correct.
But in deciding if we get to the penalty phase in this case, right? So if you find that the state has proven him guilty beyond a reasonable doubt, or we have failed to prove that he's not guilty by reason of insanity, and we're in the penalty phase, that is an aggravating factor, that he's been previously convicted of murder.
Okay.
And so that's why I'm asking is some people say, if I know that someone is already convicted of murder of a pregnant woman serving a life sentence, then death really becomes the only appropriate penalty for this second murder. Does that make sense?
It makes sense. What you're saying makes sense, yes.
Tell me what you think.
I don't think that I think it all just depends on what they've done in circumstances that are, not circumstances, you didn't like that word, the factors that are presented. So it has to just be, I don't know. It's hard to stand in front of everybody, I'm sorry.
You're doing great.
Just like whenever your kids do something wrong, you don't assume because they did it one time that they're a horrible person.
Okay.
And they're going to make mistakes. So.
That is true. I don't have a problem with the word circumstances. I just always want to make sure we're on the same page.
Gotcha.
Right? So we've never met, and so I'm trying to figure out, what you mean when you say certain things. It's not that you're saying anything wrong, I promise. You would probably not be surprised if I said that people have differing opinions on this sort of stuff.
Yes.
Right? And the law allows that and contemplates it. That in order for a just verdict to be returned in this case, all 12 jurors' individual moral assessments as to whether or not Mr. Loyd lives or dies have to be heard. With me?
Yes.
Death is never required, not in any case, not in the worst imaginable case you can conceive of. And so the process, again, if we're in the second part, the penalty phase, is has the state proven the existence of at least one aggravating factor? Is it sufficient to warrant the death penalty? Does the aggravation outweigh the mitigating circumstances? And then the last question is death the appropriate penalty? And the answer to that last question never has to be yes. No matter if you check yes, 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 you may say no. And mitigation, what we've already talked about, it does not have to be unanimous, and each juror may see a piece of evidence differently. okay? And so in talking about that, when we talk about meaningful consideration, right, you seem like a thoughtful person. I don't think you're going to ignore anything you hear. But meaningfully consider means I've heard it, I've internalized it, and it may have an effect on my verdict as to life or death. Does that make sense?
That does make sense.
So again, if we're talking about the intentional premeditated killing of a law enforcement officer, do you think you could meaningfully consider something like the defendant experiencing the effects of racism?
I do.
Okay. Sometimes when jurors are deliberating, things can get contentious, right? Again, strong opinions. You are certainly not going to bully or badger anybody to change his or her opinion to agree with you, right?
Correct.
And you're not going to allow anybody to do that to you.
No.
May I have just a moment, Your Honor?
Yes, ma'am. Thank you. Does either side need to approach?
No, Your Honor.
All right, ma'am. We're going to send you through to the final round of questions,
Okay.
of questioning. So you're juror number 35, right?
Yes. I'm
Okay.
sorry.
And that
You
means,
want that? I'm so sorry.
if you'll hand your badge to the deputy, you're now going to become a purple dot.
Ooh.
We call people by colors,
Okay.
switch the colors out for the final group. So we're going to give you a packet. That packet includes a slip of paper that tells you a phone number that you call to find out when you're supposed to report back for final questioning. I don't know yet because I don't have enough people to call them back.
Okay.
I strongly suspect it will be next week. There's a slim possibility it'll be Friday, so call tomorrow after 5 just to find out.
Okay.
That is the day we're going to pick the jury and sequester the jury. So when you come back, you have to bring a suitcase with you.
Oh.
Just leave it
Okay.
in your car. If you don't need it, you just drive home with it. If you do need it, well, we'll pick it up. We'll make arrangements for you to get it.
Okay.
That packet also includes a sequestration packet. Gives you a lot more detail about being sequestered and the rules, and what we suggest you bring with you and pack.
Okay.
And lastly, there's a letter in there for your employer telling them that you have to return for yet another day of jury questions. All right? Any questions?
No, ma'am.
Thank you so much for your patience this morning. You have a good day.
Thank you so much.
All right, I should have 2 left in that jury room. Is that correct? Give me 1 second, and I'm going to need both of them because they weren't here for the original instructions. So. All right, let's bring them both in, please. It is. We have fixed the glitch in my real time, and I appear to be able to. Yeah, just put them right in the middle. I appear to be able to see everything. Thank you. It was a little frustrating this morning. It's okay. Adds to the excitement of the day. Thanks. Good morning, folks. How are you? All right. Yeah. I'm going to give her a second to shut down her phone. And then if you'll both stand and raise your right hand, we need to re-swear you in. Okay, thanks.
In which of you solemnly swear or affirm that you will answer truthfully all questions asked as potential jurors, so help you God?
All right, if you'll both have a seat. I have some instructions that I gave the other group before you all got here. So that's why I held you to the end to bring you out, because I need to instruct you too, because you hadn't You weren't here when I did that originally. So let me tell you, welcome to day 2 of jury selection. As I told you, this is a capital case, a death penalty case. Death is a possible sentence in this case. So we do this a little bit differently. We bring the jurors in on 3 separate occasions if you make it all the way through. This today is individual questioning. In order to go through that individual questioning, I'm going to give you some more facts, give you some instructions, explain to you how these cases are tried. And then we'll talk to you one at a time. So let me start with telling you what Mr. Loyd is charged with. Mr. Loyd was charged by indictment. I have a copy of it in my hand. An indictment is the method we use in Florida to tell someone what they're being charged with. All right? You have to tell people this is what we're accusing you of doing. This is how we do it. Indictments are not evidence of guilt. You cannot assume that because he was indicted, he's guilty. All right? This is just the charges. And you can't use these to determine guilt or innocence. All right? Mr. Loyd is charged in count 1 with first-degree murder with a firearm of a law enforcement officer, count 2 attempted first-degree murder with a firearm of a law enforcement officer, aggravated assault with a deadly weapon, carjacking with a firearm, and possession of a firearm by a convicted felon. The first count, first-degree murder of a law enforcement officer, is the count that if he's convicted, that count carries a possible death penalty. We do not have an automatic death penalty in the state of Florida for anything, all right? It's a possible penalty. So let me explain to you first how these cases are tried. They're tried in 2 phases. Phase 1 is referred to as the guilt phase. The guilt phase of a capital case is pretty much the same as every other criminal case. Jurors sit in those chairs. They're sworn in as jurors, and you sit in those chairs. You're going to listen to the evidence in the courtroom. Evidence is going to come either from the witness stand. The witnesses testify right next to me in this little box right here. So they're sworn. The attorneys can examine and cross-examine them. It means they can ask them questions. But you listen to the witnesses testify. There may be physical evidence that's introduced. Videos, photographs, documents, just things that are introduced into evidence. Jurors have to be able to hear it, see it, read it if it's a document. So you listen to both, to all the evidence that's introduced. Then at the end of that, I'm going to give you jury instructions. The jury instructions are the law that the jury is required to follow in the case. It's not optional, it's the law. The jury determines what the facts are. The judge tells you what the law is. The jury applies the facts to the law and determines whether or not someone is guilty or not guilty. So in the first phase, in the guilt phase, you're going to be asked to return a verdict of guilty or not guilty on all counts. And your verdict must be unanimous on all counts, meaning each juror must agree on each count whether to acquit or convict. The burden of proof for the state is the same in the guilt phase of a capital case as it is for every other type of criminal case, and that is proof beyond a reasonable doubt. The instruction you will receive on reasonable doubt is identical to the instruction given in all other criminal cases. The burden on the state is not higher because of the potential penalty. When you're deciding guilt in phase 1 of the case, you're going to be instructed to ignore any possible sentence in this phase. In other words, we ask you to decide whether the defendant is guilty or not of the charges, including first-degree murder, on their own merits, and you will be told to disregard the possible consequences of your verdict. The only question you're to answer during the guilt phase is whether the defendant is guilty of murder, as well as any of the other offenses charged, or guilty of a lesser included offense, or not guilty. We expect you as jurors to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. Now, if and only if the jury returns a verdict of murder in the first degree, the first count, then the jury reconvenes for the purposes of deciding a verdict as to which sentence, death or life imprisonment without the possibility of parole, should be returned. That's what we refer to as the penalty phase. If that happens, there's a special set of rules and instructions that I would give you. At each stage of these proceedings, I will be instructing you all as to what it is you're supposed to be doing. Today, I'm not going to give you the instructions on the penalty phase. I'm just going to give you an overview of what it's like so that we can ask you some questions about your ability to participate in that type of a phase, all right? The death penalty in Florida is reserved for one class of crimes only, and that is murder in the first degree. Because of that, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. The circumstances are known as aggravators and mitigators. The state relies on the ones called aggravators. They're required to prove these beyond and to the exclusion of every reasonable doubt, and aggravators are limited to 16 by statute. All right. The defense relies on mitigators. The mitigators do not need to be proven beyond a reasonable doubt. A mitigating circumstance need only be proved by a greater weight of the evidence. It's a lesser standard. Mitigating circumstances are not limited by statute, and they include matters that may be relevant to the defendant's background, character, or the circumstances surrounding the offense. They are offered as the basis for a verdict of a sentence of life in prison without the possibility of parole. Life in prison without the possibility of parole means exactly that in Florida. The defendant will die in prison. We do not have parole in this state. Before you may vote that the court impose a sentence of death, the state must prove one or more aggravating factors beyond a reasonable doubt. All right. If they do not do that, death is not a possible sentence. So there has to be at least one aggravator proven beyond a reasonable doubt. So the penalty phase is another little trial that goes on. The state's going to put on their evidence of aggravators. The defense is going to put on their evidence of mitigators. Jurors must be able to openly and fairly consider all of this evidence, both the aggravators and the mitigators. And by that I mean you can't be sitting in the jury box thinking, okay, I'll listen and then I'm going to vote the way I was going to vote anyway for life or death. You have to actually listen to what's being presented. You've got to process it, absorb it, think about it. At the end of that presentation of evidence by both sides, I will give you the instructions on what the law is. Then you're going to go back in that jury room you've been hanging out in this morning with your fellow jurors. Now you're going to weigh aggravators and mitigators. Weighing aggravators and mitigators isn't mathematical or mechanical. You don't add up the number of aggravators, add up the number of mitigators, whoever has more wins. That's not how it's done. What we mean by weighing is each juror individually, because this is an individual decision, has to decide what is important to your decision and what is not. You have the right to find that you're not persuaded by this aggravator or that mitigator, or you don't believe them, you don't find the evidence compelling, or you can decide this one aggravator or mitigator is very important to my decision, meaning you're giving it great weight. That's what we mean by weighing them. You can discuss it with your fellow jurors, but it is an individual vote, and each juror must make their own decision about the weight given to aggravators and mitigators. Regardless of your findings in this respect, regardless of the weight given to aggravators or mitigators, you are never compelled nor required to vote for a sentence of death. The first thing a jury has to do is determine that at least one aggravator has been proved beyond a reasonable doubt. If there is no aggravator proven beyond a reasonable doubt, you're done. The sentence is life without parole, okay? But if there's an aggravator proven beyond a reasonable doubt, and that finding has to be unanimous by the jury, then you go on to the weighing process that I discussed with you all. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. In other words, the vote for death must be unanimous. All of the jurors must agree. The vote for life does not have to be unanimous. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If, after deliberating, the jury unanimously agrees the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. Let me also say this to you all. The fact that I'm talking about the death penalty is not to be taken by you as any indication one way or another that this case is one which justifies a death penalty. I don't know that, and you don't know that. The only reason we're discussing this is because it's a possibility in this case, and we need to know before we start the trial that you're able to follow the law and do your jobs as jurors in these types of cases. This is all a very broad outline of the penalty phase. It's not the specific instructions, but it's enough for you to be able to answer our questions today. We are going to be asking you some questions about the death penalty, including, do you have any thoughts about it? Are you completely opposed to the death penalty? Are you someone who believes that if someone is convicted of first-degree murder, death is the only sentence? That's it. That's what you're voting for. Can you go through the process I just described with an open mind, weighing aggravators and mitigators? It's those types of questions we're going to be asking you. I'm going to switch gears slightly to the insanity. Mr. Loyd has raised the defense of insanity in this case. There is a jury instruction on it that would be read to you. But at the moment, here's what you need to know for today's purposes. Number one, insanity is a defense to a crime. It's raised in the guilt phase, and it's something that's brought up when the jury's making the decision about whether someone's guilty or not. It is the one time in the guilt phase that the defense has the burden of proving it, not the state. The defense has to raise insanity and prove it by clear and convincing evidence. I'm going to give you the definition of insanity, and we're going to have some questions for you about this. A person is considered to be insane when he had a mental infirmity, disease, or defect, and because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. The questions are going to center about your feelings about this type of a defense and whether, if it's proven, you could accept that kind of defense. And lastly, I'm going to read some statement of the case to you. On the morning of January 9th, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide, when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire, before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. That last part that I read to you about Ms. Dixon, the murder of Ms. Dixon and her unborn child, she was pregnant at the time. That cannot be used by you to determine whether or not Mr. Loyd is guilty of these charges. They're two separate cases. That information can only be used in the penalty phase, but I'll give you some further instructions on that. So let me ask both of you a question that you can answer simply by raising your paddles. Have either one of you heard anything about this case? So both of you have. Okay. And based on what you've heard, and again, just raise your paddles. Based on what you've heard, have either one of you formed an opinion as to whether or not Mr. Loyd is guilty? So no paddles. Do either one of you have a personal, religious, or moral objection to the death penalty such that, regardless of what the facts, the evidence, or the law is, you could never vote to impose death on someone? Neither one of you raise your paddles. And do either one of you have a belief that if someone is convicted of first-degree murder, intentionally killing another person without having any legal reason to do so, for example, self-defense or insanity, they just killed someone, that if they're convicted of that, they should be sentenced to death? All right, neither one of you raised your paddles. So Juror number 21, if you'll step back in the jury room, we'll be right with you. Let me talk to juror number 9 for just a second. Thank you.
Okay. You going through something right now? You okay? You sure? If you could, you adjust the cord. Yeah.
All right, ma'am, you appear extremely upset. I have to talk for the record, so you appear extremely upset to me and you're crying. What's the problem?
I had a brother that was murdered.
I'm so
like
sorry.
His second mom. I helped raise him.
Okay. Did she have, I have a box in here if you need it. Okay. I'm so sorry to hear that, Mount.
It's like bringing it all back.
Okay. Based on that, ma'am, do you think that you could be fair and impartial in this case? All right, state.
Statement, Your Honor.
Defense. All right, ma'am, this isn't the case for you. I'm sorry that this has upset you so much. You're free to go. Thank you.
Apologize.
That's all. You don't need to apologize. Have a good day, ma'am. Let's bring in. Juror in seat 21, please. Good morning again.
Good morning.
How are you doing?
I'm doing okay. How you doing?
I'm doing all right. All right, I'm going to ask you a few questions. There aren't any right or wrong answers to my questions or to the questions the attorneys ask you. The point of these questions is to try and determine whether you can do your job as a juror in this type of case. The only correct answer is the truth, okay? So let me start by asking you what it is that you know about this case. You got to get that mic closer to you.
I know that Mr. Loyd, he killed Miss Dixon and an unborn child, and then he was on the run. And I couldn't remember how long it took for him to get caught, but I know he was on the run for a week, like you said. And then the police officer, I know he killed the police officer, I heard he killed the police officer in the Walmart parking lot. That's it.
Did you hear anything about when he was caught?
I think he got beat up.
Okay. Anything else you remember about that?
No, man.
Did you hear anything about who beat him up?
Police officers.
Okay.
I called him.
How much of the coverage did you watch about this?
Not much. I didn't follow it much. I was a senior in college at the time. So I was playing basketball. I was kind of just focused on that. It was just something that was on TV.
You were enjoying the college life?
Yes, ma'am.
All right. Were you a college student here or out of town?
Here.
Okay. Were family or friends or your fellow students talking about the case?
Some of the students were on campus where I was going to school at, and it was a small school, so it was a talk for a little bit, but I don't know, I didn't really get into too many conversations about it.
All right. So based on, subsequent to that, did you hear anything, read anything, see anything on the news?
After or during that time?
After.
No, ma'am, not really.
Okay. Based on that, did you form any opinion, even back then, as to whether or not Mr. Loyd was guilty?
I don't remember forming a definite opinion because I didn't really know exactly what happened.
Right.
And at that time, I was big, you can't believe everything that you see on the news. So I didn't form a definite opinion. I didn't want to be wrong, so it was just I see what they're saying, but you never really know.
Okay. In order to sit as a juror in a criminal case, in all criminal cases, you have to be able to presume someone to be innocent until and if the state can prove they're guilty beyond a reasonable doubt. Can you do that in this case?
Yes, ma'am, I can.
Okay, you hesitated for quite a while. What was your hesitation?
I was thinking about if you were asking me to hold, in my eyes, see him as innocent until he's been proven guilty. So I was just kind of processing the question and making sure that that was what was asked.
Okay. So do you have an opinion on the death penalty, sir?
Yes, ma'am.
What is it?
It's kind of based off of my interpretation of the Bible,
Okay.
life for life, but then grace is involved as well. So I'm still trying to figure it out, what my opinion is. I don't know if he's asked for salvation or if he's asked for grace, if he's repentant for his sins. I'm not even sure if he's guilty. So yes, I do have an opinion, but I'm still trying to sort it out, figure it out.
All right. It's not an easy question. So let me talk to you a little bit about the death penalty and first-degree murder. As I said, first-degree murder is the intentional killing of another human being, and there's no legal reason for it. It's not self-defense. You're not insane. So if someone is convicted of first-degree murder, all defenses have been rejected by a jury, and that finding has been made beyond a reasonable doubt. If at any point I lose you, let me know, okay? Because these are all new concepts for most folks. So the first thing that has to happen is there has to be a conviction for first-degree murder. Now there's a penalty phase. Are you someone that if you had convicted someone of first-degree murder, you would think that death was the appropriate penalty?
No, ma'am, not in every case.
Okay. If I add to that scenario the fact that the person that died was a law enforcement officer, would that change your answer?
No, ma'am, it wouldn't.
All right. And if I add to that scenario the fact that the person now convicted of first-degree murder had previously been convicted of murder, would that change your answer?
No, ma'am.
Okay. You heard me describe the process that you have to go through in the penalty phase, listening to the state, listening to the defense. You have to have an open mind. Do you have any doubts about your ability to go through that process?
Yes.
Okay, what are your doubts?
I don't know, for me personally, it's a struggle. I would feel as if I have somebody's life in my hands.
Right.
And that's huge. To me, I'm just a high school teacher. So I don't know, it's just different. It's a huge responsibility, and I know that that's something that I would kind of battle with on the daily. Yeah, it's tough.
I'm not being facetious. It's not supposed to be easy, all right? These types of decisions are things that we would hope jurors would give extremely serious thought to before they reached a decision one way or another, all right? So the question for you, and the only person who can answer this question is you, is in order to sit as a juror in these cases, you have to be able to consider both sentences. So if you went through this entire process, you heard all the evidence in the penalty phase, you've weighed the factors out, the aggravators, the mitigators, you're back in that jury room, and you believe that the appropriate sentence is life without the possibility of parole, could you vote for that?
Yes, ma'am, I could.
If you believed that the appropriate sentence was death, could you vote for that?
Yes, ma'am.
Okay. Do you have any doubts about your ability, not about the wisdom of a decision you might make, but about your ability to make the decision? Do you have any doubts about that?
No, ma'am, I don't.
All right. And you understand, you're never required to vote for death, but you have to be able to consider it, and if you believe it's the right sentence, vote for it, if that's what you truly believe. If not, again, you're never required to vote for death.
Yes,
all right?
ma'am.
You can check off every box for death and still say life. You understand that?
Yes, ma'am.
All right. Let me switch to the insanity defense and ask you about that. You heard me explain burdens on the defense. It's the guilt phase. You're trying to decide if he's guilty or not. You've heard all the state's evidence, you've heard all the defense's evidence. You're convinced by the defense's evidence that Mr. Loyd was insane at the time. Would you be able to vote not guilty by reason of insanity?
Yes, ma'am.
Right. And then lastly, do you think you can put the murder of Ms. Dixon and her unborn child out of your mind during the guilt phase of these proceedings? In other words, you can't use it to decide whether he's guilty of this or not.
Yes,
All right.
ma'am, I could.
Any doubt about that?
No, ma'am.
All right. Thank you so much, sir. I appreciate your candor. I'm going to turn this over to the state. Mr. Buxman, you may inquire.
Can we approach beforehand?
Yes.
Thank you, Your Honor.
All right, sir. We appreciate you coming in. We appreciate your candor and your willingness to serve. I'm going to excuse you as a juror in this case. You're free to go. Thank you. All right. So what's the update? Are they, Deputy, are they coming or they've been told they might be able to come? They're arriving? Okay. All right. Since it was obvious to the court that we were going to finish very early this morning, here's what we did. We called the jurors for the 2 o'clock panel and asked them if they could come in early. So the following jurors are arriving at 1 o'clock, which is when we're going to resume, from the 2 o'clock group, which consists panels 8 and panel 9. Jurors from panel 8 are 50, 54, 55, and 56. Jurors from panel 9 are 1, 13, 17, 23, 29, 30, and apparently there's some jurors from panel 10, because I have a juror number 3 coming from panel 10. So we're going to start back, we're going to break for lunch now, we're going to start back at 1 o'clock. We'll start with these jurors, and I'll do all the pre-qualification with them. If the 2 o'clock group arrives, I'll come in and instruct the 2 o'clock, see who, do the pre-cause things. All right, so maybe we can get ahead of ourselves this afternoon. Yes, sir, Mr. Williams. Did you want to say something?
I do.
Go ahead.
Thank you, Your Honor. I think we're all recognize we're getting closer, and it's a scheduling issue. We have some, I would say probably close to 10 at this point, motions that are pending. And we also still have, I know the state has 3 expert depositions it needs to complete. I guess I'm just asking that the court keep that in mind. I know you'll keep us informed. Maybe do those motions on Friday if possible, but I just want to remind Your Honor that we do have these issues floating about, that's all.
I'm aware of that. I have a schedule in my mind that I'm going to follow, but we are getting close. I just want to see if I believe that we can get enough people by tomorrow. We're breaking at noon tomorrow with jury selection before I announce the schedule. All right, but I'm going to give you all plenty of warning. And I'm aware of the fact that clearly I'm not keeping you all busy enough because you're filing motions that my JA keeps sending to me that I haven't read. And so I have a list here of motions that you all have filed. So
very good, Your Honor.
Thank you. All right, have a good lunch, folks. I'll see you after lunch. 1 o'clock. Thank you.